It is 10:30 p.m. You are driving home. Maybe you're coming back from a double shift. Maybe you just picked up milk from the grocery store. Your mind is on tomorrow's bills, or the game you missed, or just the comfort of your own bed. You see the lights in your rearview mirror. Your heart rate spikes. That is biological. That is instinct, but your logical brain takes over instantly. You tell yourself, I'm fine. I wasn't speeding. My registration is current. I am a law-abiding citizen. You pull over. You turn off the engine. You roll down the window. The officer approaches. He's polite. You're also polite. He asks for your license and registration, and you hand them over. And then he asks the question that changes everything. Do you have any weapons in the vehicle? Now, you are a legal gun owner. You have your permit. You have your training. You believe in transparency. You believe that if you have nothing to hide, you have nothing to fear. So, you answer honestly. Yes, officer, I have my firearm, and I have my permit. You expect him to nod, check your ID, and send you on your way. But he doesn't. The air in the conversation changes. The politeness evaporates. He asks you to step out of the car. Suddenly, you are standing on the side of a busy highway, cars flying past you at 60 miles per hour, while a stranger armed and backed by the power of the state reaches into your sanctuary, takes your property, and begins to inspect it. He turns it over. He shines a flashlight on it. He is writing something down. 20 minutes later, you aren't driving home. You are in handcuffs. You are sitting in the back of a squad car. You are being charged with a felony. Why? You bought the gun legally. You carried it legally. You drove legally. You are going to jail because you didn't know that the moment the officer touched your gun to check it, he wasn't securing his safety. He was conducting a warrantless search. He was breaking the law to enforce the law. And because you didn't know the playbook to stop him, you walked right into a trap that was set the moment you said yes. Today, we are going to dismantle that trap. I am going to give you the legal playbook, specifically a 2-question script that forces the police to stop the fishing expedition and follow the Constitution. To understand why this happens, we have to look at the board on which this game is played. The rules of this game were not written yesterday. They were written over 200 years ago, specifically to prevent exactly what just happened to you on that roadside. The Fourth Amendment to the United States Constitution is not a suggestion. It is not a guideline that officers can choose to follow when it is convenient. It is a shield. It is the only thing standing between you and the overwhelming power of the government. Let's look at the text, because words matter. It says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Notice that word, effects. Your car is your effect. Your gun is your effect. Your phone is your effect. The Founding Fathers added this specific protection because they lived under a tyranny where soldiers could kick down doors and rummage through personal belongings just to see if they could find a crime. They called them general warrants. A general warrant was basically a blank check. It allowed the king's men to search everyone, everywhere, in hopes of finding someone doing something wrong. The Fourth Amendment was written to kill the general warrant. It demanded specificity. It demanded probable cause. But today, in the 21st century, we don't have general warrants on paper. Instead, we have something that feels very different but functions exactly the same. We have the traffic stop investigation. Over the last 30 years, the courts have given police officers incredible leeway in the name of one specific thing: officer safety. We all agree police work is dangerous. Traffic stops are volatile. We respect that reality. Because of this danger, the Supreme Court has ruled in cases like Pennsylvania versus Mims and Terry versus Ohio that officers can take temporary control of a situation to ensure they don't get shot. They can ask you to step out of the car. They can pat you down if they have reasonable suspicion you are armed and dangerous. These are tools meant to preserve life. But here is where the corruption of the law happens. Here is where the shield begins to crack. Police departments and aggressive prosecutors have realized that officer safety is a magic password. They realize that if they say they are doing something for safety, judges rarely question them. So, they started using safety as a Trojan horse. They take your gun for safety. That sounds reasonable, right? They don't want a loose firearm during a stop. But once they have it in their hands, they aren't just holding it to keep everyone safe. They are investigating it. They are running the serial number through a national database. They are checking if it was stolen in 1995. They are checking if the previous owner had a warrant. They are conducting a forensic investigation on the side of the road, without a warrant and without your consent. They have turned a traffic ticket into a criminal inquiry. And the most dangerous part? You are letting them do it because you think they are just checking. You think this is standard procedure. It is not. It is a violation of your civil rights disguised as a safety precaution. Let's break down the mechanism of this trap. There are two specific legal tripwires that the police cross when they do this. If you know these two case laws, you can spot the violation in real time. If you don't, you're flying blind. The first mechanism is time. In 2015, the Supreme Court decided a case called Rodriguez versus United States. It is arguably the most important traffic stop case you need to know as a gun owner. Before this case, police believed that as long as a traffic stop wasn't unreasonably long, say, an hour, they could do whatever they wanted in the meantime. They could walk a drug dog around your car, they could grill you about your past, or they could run the serial number of every electronic device in your backseat. But the Supreme Court changed the rules. They ruled in Rodriguez that a traffic stop is not an open-ended investigation. It is a limited seizure. Think of a traffic stop like a mission in a video game. The mission has a specific, singular objective: address the traffic violation. That is it. That is the only reason the government is allowed to detain you, to address that specific infraction, whether it's speeding, a broken taillight, or an expired tag. The court ruled that the police cannot extend the stop longer than the time it reasonably takes to complete that mission. Think of it like a permission slip from the courts. The Constitution gives the officer a permission slip that says, "You may hold this citizen for 10 minutes to verify his license, check for warrants against him, and write a citation." The moment the officer stops working on the ticket and starts doing something unrelated, like calling in a drug dog, or asking you about your travel plans, or running the serial number of your firearm, that permission slip expires. This is the critical distinction. Police can do things related to the mission. They can check your license. They can check your registration. They can check you for outstanding warrants. Those are safety checks related to the driver. But the gun is different. The gun is property. If the officer has all your information, and he could be writing the ticket, but instead he is sitting in his cruiser waiting for dispatch to run your gun's serial number, he is violating your Fourth Amendment rights. He is extending the stop without reasonable suspicion. Running a serial number is not part of a traffic ticket. It is a fishing expedition. It is a separate investigation. And Rodriguez says that you cannot be held hostage on the side of the road while the officer decides to go fishing. If the ticket is ready, or should be ready, the stop must end. Anything that happens after that timeline is fruit of the poisonous tree. Now, the second mechanism is even more subtle, and it catches almost everyone. It is the legal sleight of hand that police use to justify their actions. It's called the plain view myth. Officers will often tell you, and they will certainly tell the judge, "I saw the gun, so I ran the numbers. It was in plain view." This is usually a lie, and the Supreme Court case Arizona versus Hicks proves it. To understand why, you have to understand the difference between looking and searching. If an officer walks up to your car and sees a bag of cocaine sitting on your passenger seat, that is plain view. He didn't have to touch anything to know it was illegal. The illegality was immediately apparent. But a gun is different. Owning a gun is not illegal. Seeing a gun is not seeing a crime. Let me tell you the story of Arizona versus Hicks, because it is the exact legal precedent that protects you in this scenario. In 1987, police entered an apartment in Arizona because a bullet had been fired through the floor, injuring a man in the apartment below. The police were there legally. They were operating under exigent circumstances to look for the shooter and for other weapons. They had a right to be in the room. While they were there, one officer noticed some very expensive stereo equipment. He thought it looked out of place in that specific apartment. He suspected it was stolen, but he didn't know it was stolen. The serial numbers were on the back of the turntable facing the wall. So, the officer reached out and very gently moved the turntable. He didn't break it. He didn't take it apart. He simply lifted it just a few inches and turned it so he could read the back. He wrote down the serial numbers, called them in, and confirmed they were stolen. They arrested Hicks. It seems like good police work, right? The Supreme Court said no. They ruled that the moment the officer moved that turntable even by a few inches, he conducted a search. The court established a bright line rule. A search happens the moment you manipulate an object to expose information that was not already visible. Since the officer didn't have a warrant to search the stereo, and he didn't have probable cause to believe it was stolen before he moved it, the search was illegal. The evidence was thrown out. Now, apply this logic to your firearm on the side of the road. The officer takes your gun for safety. He holds it. That is a seizure. He is allowed to seize it to neutralize a threat to his life. We accept that. But think about where the serial number is on a modern handgun. It's usually small. It's often stamped on the slide or the frame, or sometimes hidden underneath the grip or obscured by the holster. To read it, he has to turn the gun over. He has to manipulate it. He has to bring it closer to his face or shine a light at a specific angle. Just like the stereo in Arizona versus Hicks, the moment he manipulates your property to gather information he couldn't see otherwise, he is conducting a search. Does he have a warrant to search your gun? No. Does he have probable cause that the gun is stolen? No. He just has a hunch. He is just curious. Therefore, running that number is an illegal search. He has crossed the tripwire. The plain view doctrine does not apply because the serial number was never in plain view until he violated your rights to find it. So what, you might ask? You might be sitting there thinking, I bought my gun at a reputable shop. I have the receipt. I'm a law-abiding citizen. Let him run the number. If it comes back clean, no harm, no foul, right? Wrong. This mindset is dangerous because it assumes two things that are simply not true. First, that the government database is perfect. And second, that the system is fair. Neither is true. Let me paint 3 specific scenarios for you. These aren't hypothetical fear-mongering. These are things that happen to real gun owners every day. Scenario A is what I call the clerical error nightmare. Imagine you bought a used Glock 19 from a pawn shop 5 years ago. The shop was legitimate. The background check passed. You have done everything right. But what you don't know is that 15 years ago, that gun was reported stolen in a different state. The police in that state recovered it, returned it to the original owner, and the owner eventually sold it to the shop where you bought it. But this happens all the time. The police clerk in that other state forgot to remove the serial number from the NCIC stolen gun database. It is a simple clerical error, a forgotten keystroke. The officer on the side of the road runs your number. It was stolen. Suddenly, the tone doesn't just change, it explodes. You are now the subject of a felony stop. Guns are drawn. You are pulled out of the car, forced to your knees, and handcuffed. You are arrested for possession of stolen property. Your car is impounded. You spend the night in jail. You spend $10,000 on a lawyer and 6 months of your life proving a clerical error. You win eventually, sure, but the process is the punishment. Scenario B is the registry trap. In states that have gun registries, the data entry is notoriously slow. Let's say you bought a gun legally yesterday. You are taking it to the range today. The dealer sent the paperwork, but the state police haven't processed it yet. The database hasn't been updated. The officer runs the serial number. It comes back registered to someone else, the previous owner. Now you are being detained for investigation of an illegal transfer or theft. Why do you have Mr. Smith's gun? The officer doesn't believe your story about buying it yesterday. He trusts his computer screen. Your quick trip to the range just turned into a 4-hour interrogation on the side of the highway. And finally, Scenario C, the fishing expedition success. Even if the gun is clean and the database is perfect, you still lose. Why? Because by consenting to the gun check, or by not objecting to the delay, you have given the officer the one thing he desperately needs to find something else: time. Remember the Rodriguez rule? He can't hold you forever, but if you sit there quietly while he runs the gun, you are implicitly consenting to the delay. That is 15 extra minutes. That is 15 more minutes for him to shine his flashlight into your backseat looking for probable cause. That is 15 more minutes for AK-9 unit to coincidentally arrive and walk around your car. By allowing the gun check, you have handed him the time he needs to manufacture a reason to search the rest of your life. You have opened the door to a room you never should have let him enter. So how do you stop this? You cannot physically stop the officer from taking your gun. If you fight on the roadside, you lose. Sometimes, you lose your life. Your battle is verbal. Your weapon is not your firearm. It is the public authority defense. You need to lock the officer into a legal box where he has to choose between letting you go or violating your rights on camera. Here is the 2-question script designed to end the interrogation and stop the fishing expedition. First, a quick word on prevention. If you live in a state where you are not required to inform the officer you have a weapon, do not volunteer the information. The easiest way to avoid a serial number check is to never introduce the gun into the conversation. If the law says you must inform, then inform. But do not add conversational filler. Say, "Officer, I am required by law to inform you I have a concealed carry permit and a firearm on my right hip." Then, stop talking. But let's say he takes the gun. He walks back to his cruiser. He is sitting there. Minutes are ticking by. He is fishing. When he comes back, or if he shouts from the car asking for more details, you need to set the timer. You need to interrupt his flow. You ask question number 1. "Officer, am I being detained, or am I free to go?" This forces a binary choice. It cuts through the ambiguity. If he says, "You are free to go," then leave. Immediately. Do not stay to chat. If he says, "You are being detained," he has now officially started the clock on the Rodriguez rule. He has admitted on record that you are not free to leave. Now, you follow up with question number 2, and this is the specific question that stops the serial number check because it exposes the lack of reasonable suspicion. You ask, "Officer, what specific crime are you investigating that justifies this detention?" Why does this work? Because a traffic infraction is not a crime that justifies holding you to check a gun. By asking this, you are signaling to his body camera and to him that you know the scope of the stop. You are effectively saying, "I know that writing a speeding ticket does not require checking a serial number. I know that the mission of this stop does not include a forensic investigation of my property. I am putting you on notice." If he says, "I'm just checking your gun," you have him. You have established that the delay is unrelated to the traffic stop. If he continues to hold you solely to check the gun, you now have the video evidence to win in court because he has admitted to extending the stop without a crime to investigate. The police have a difficult job. We respect that. But efficiency in police work cannot come at the cost of the Constitution. The Fourth Amendment wasn't written for the guilty. It was written for the innocent. It was written for you. Don't be rude. Don't be aggressive. You will never win an argument on the side of the road. But do not be a doormat. Know the tripwires. Watch the clock. And when the time comes, ask the questions. Because if you don't know your rights, you simply don't have them.